Some fireworks in the Chad Daybell trial. And actually, these fireworks are not as a result of hearing some major breathtaking evidence, listening to some text messages or emails exchanges or voicemails or phone calls, nothing to do with the actual trial. These are fireworks that have to do with a different attorney who filed a motion on this case before jury selection. And this attorney was the name of Terry Ratliff, a licensed attorney, and he filed a motion into this case. He filed a motion to intervene, which means that he is now coming as a third party into this case. So you got the state, who's one party, the prosecutor. You've got the Chad Daybell on the other side, who is represented by John Pryor. So he has counsel. Now a third person, a third party wants to intervene into the action and say, hey, I also get a seat at the table. And this happens very often in civil cases when you're talking about cases for money damages. So there can be a lot of interested parties in the outcome of that case, which could affect them. So, for example, let's say you have medical providers that want to intervene into a case so that they can ensure that their bills are paid out of the proceeds of this trial. So you can have interveners like that. This is a criminal trial, so it's a little bit different. So here you've got Terry Ratliff, who's a licensed attorney, filed the motion, and the motion has been sealed. So I have not been able to read the motion. If somebody did get their hands on the motion, I'd love to see it. But he lays out some sort of basis why he should be able to intervene into this criminal trial going on right now with Chad Daybell. So what the judge did is what is being shown around now is the show cause hearing. So a lot of times what the judge will do is the judge will require someone to attend a hearing so that they can show to the court why they shouldn't be held in contempt of court, or you have to explain your actions to the judge. That's a show cause hearing. And that seems to be what was occurring during this hearing that is going around now. So you got this guy, Terry Ratliff, an attorney. He filed this motion. They have a show cause hearing, and that's where the judge, who very noticeably was not very happy about this filing. And there's a number of reasons for that. So for the first of all, one of the reasons is that this was filed literally Friday night before midnight, March 29th, and jury selection is supposed to begin the following Monday. And the court didn't even actually get the motion until Sunday. So now this is a day before the trial is supposed to start, Chad Daybell jury selection, and all of a sudden the court's getting this motion to intervene and to continue the trial. Continue the trial means to adjourn the trial. So stop. No jury selection. Let's put everything on pause and wait for, however much time they ask in the motion. So that was what's filed in this case by Terry Ratliff. Now so that's number one. The first thing that gets on the judge's nerves is that all of a sudden you're filing this motion Friday night. Like, where were you? This case has been going on for a long time. They've had the trial date set for a long time. You want to continue the case. You feel you have good cause. What do you got to wait for the last second for? That's number one. Number two is that it was signed by Mr. Ratliff, and this is all from reports that we're getting watching the hearing. That's where I'm getting my information from. So it's signed by Mr. Ratliff, who is an attorney, and he signs it as attorney for defendant, Chad Daybell. That's how he signs his name on behalf of a pleading. Now, when you're an attorney, you always let the court know who you're representing in your pleadings, in your filings. In the caption of the case, it's who you are, what attorney, what firm you're from, and who are you representing. And in a number of different places in his motion, he refers to himself as attorney for defendant. That was another thing that caused the judge to not be so happy with him, because why are you saying that you're the attorney for Chad Daybell when you're clearly not the attorney? Have you been retained by Mr. Daybell? Has John Pryor asked you to help him out? Now, he did say, Terry Ratliff, he did say that John Pryor had some conversations with him, but that he was never officially retained, and he's not part of the defense team. So when you're an attorney and you're representing to the court that you represent an individual and you really don't represent that individual, the judge is not going to be very happy with you. So that's sanctionable conduct. So that's another reason why the judge wasn't happy. Also, there was many misspellings in this motion. He misspelled. It was very sloppy. So that's what it seems like. And again, I haven't seen the motion, but this is what the judge was saying, that there was things that were just misspelled. And not only that, but he got the wrong case number also. Every single case has a case number. So they got the wrong, he wrote the wrong case number as well. So all of these factors together, the judge was very unhappy. So therefore he had this hearing, and now he is going to have the show cause hearing why Terry Ratliff should not be sanctioned as an attorney for filing what could be referred to as a frivolous filing. And something that every attorney understands and knows is that there's a rule that you can be sanctioned if your pleadings are not based on your reasonable knowledge, reasonable understanding of the facts and the law. If you blatantly represent to the court false facts, or you blatantly represent incorrect case law, or you make cases up, obviously this is all sanctionable conduct. So before you put your signature on any pleading, the attorney knows that when he puts his name on that pleading, on that filing, that he is reasonably representing to the court that he did his due diligence and that he believes that the factual scenario is correct, what he's saying in his statements, and the case law is correct, or the statutes that he's citing to is correct. And here, he represented that he's representing the defendant. In this case, he's representing Chad Daybell. That's clearly incorrect. Now, his response to that was, well, this was a template. Now, right, when you're an attorney and you have to file certain documents, so all attorneys really have a database in which they have templates, right? You don't want to recreate the wheel every time you file the same type of motion. So if you, for example, let's say in a civil case, you have a motion to compel discovery. The other side is not giving you over discovery. So you may have already that template is saved in your system as a motion. It's just a template, which basically has some basic law, some basic facts where you have to kind of fill in the blanks, and then you file it with the court. Now, of course, you're supposed to change the caption if you're representing a different client now as opposed to when you wrote that motion to compel. So then you got to change the client's name, you change the court, you change the case number, and of course you have to make sure that the law is correct and you have to change the factual allegations. But a basic bare bones template most attorneys work off of. So Terry Ratliff's response to this was, well, it was just a template, and in my template, since I always represent defendants, so it said Terry Ratliff representing the defendant. So that was his argument. It's not the greatest argument because, again, you're filing with the court, and it's a very important representation that you're making to the court that you're representing this person, right? That's number one. What gets you into the door of this courtroom, into this case? That's a very important part. So that's number one. Number two, why are you filing at last minute? What's the last minute part? This really upset the judge. And all of these, you got the wrong case number. It's just very sloppy. It looks like you just did it when you were half asleep and just filed it on a whim. That's not how you file things in the court. So that was what this hearing was about, and there wasn't really such great answers. Now, also, another important part is when you file something in the court, you have to have a basis for it. Like I always talk about, you have to give the judge a basis to grant what you're asking for. So if I'm asking the judge, please give me $1 million. I need the money. That's not a basis for the judge to order someone to pay you $1 million. You have to have a good faith basis in the law and according to the factual scenario that you lay out to the court for what you're asking for. You always have to give the basis. So therefore, you have to do some research and you have to show the judge how there's certain statutes that say that you could grant what I'm asking for. There's some case law that backs you up. All this good stuff. This is what attorneys do all day. So that's also a basis for sanctions, is if you ask the court for something and you didn't do any research, you didn't provide good authority or statutes or case law to back up what you're asking for. And here also, the judge said the rules are clear. You cannot intervene into a criminal case. although you could intervene in a civil case, and it happens all the time, but in a criminal case, you can't intervene. And we've had a very similar issue. For those of you who have been following the channel so far, and if you're a new person following the channel, certainly you should subscribe and like the video so we can continue bringing you this analysis. So if you've been following this, then I spoke about this in the Karen Reed situation, where the judge or the prosecution wanted to ask the judge to have a buffer zone. And the prosecution asked for 500 feet, and there was some responses to that motion by the prosecutor. There was a response by an individual, I forgot what his name was, an attorney representing some of the picketers, and that attorney filed a motion to intervene into that case for this specific issue. And we spoke about that, how the judge right away said, you're not allowed intervention into a criminal case. We spoke about that. And the ACLU, I think it was, they filed a motion. They didn't file a motion to intervene. They filed a leave to file an amicus brief. And we spoke about this in the previous video on the Karen Reed, or one of the previous videos on the Karen Reed situation about the buffer zone. So this is very similar to what happened here. The judge said there is straight out, you're not allowed to intervene. And he quoted some case law. You're not allowed to intervene. So what are you asking me for? What basis do you have to intervene into this case? And then not only that, but to ask for a continuance, to ask for the case to be adjourned, when you've also acknowledged in your filings, and this is also true. This is what he said. The judge said, and again, can't point to the filings because it's sealed, but the judge said that you didn't ask the defense attorney. And the defense attorney did not agree that he wants a continuance. I mean, the defense attorney wants the case to go forward. And the state also wants the case to go forward. So you, as an intervener, you all of a sudden want to stop everybody who wants the case. These are the main players of the case. They want the case to continue. They want the case to start. And you want to put a pause on everything. So what's your basis, number one, to intervene in the first place? And number two, what is your basis at all that because of whatever reason you're asking, you should be granted a continuance, granted an adjournment against the interest of both parties in this case? So the response to this was Terry Ratliff said, well, look at my motion. I talked about it in my motion. And I gave you the basis why I have a right for both. But the judge wasn't buying any of it. And therefore, the judge said, I am going to order Rule 11 sanctions. That's the last thing that any attorney wants to hear. Now, what's Rule 11 sanctions? Rule 11 sanctions is actually a rule out of the rules of civil procedure. So here you get into the question. Hold on a minute. Does the judge have authority to order a Rule 11 sanctions in a criminal case? Because the Rule 11 comes from the rules of civil procedure. That's for money damages. Those type of cases. Not in the case of criminal. In the rules of criminal procedure, there's no Rule 11 that says you can sanction attorneys. So the judge actually had to do some analysis on this, and he did it on the record. And he explained that really there's some rules in criminal procedure that essentially adopt Rule 11. And this is what the judge's argument, this is what his findings, his conclusions were. That even though Rule 11 is a rule of civil procedure, but there is a rule called, he said, Rule 47 and Rule 49. Rule 47, from what I've seen, is just the rule about motion practice in criminal procedure. So in criminal cases. So nothing really that has to do with anything about civil procedure. There's nothing much in that rule. But Rule 49 really is more on point. And this is what this judge believes, adopts Rule 11. Rule 49 said the following. And it's talking about motions. And it says the following. Filing. Documents required to be served. This is referring to actually that rule is about service. When you file a motion, so you have to serve it on the different parties, serve it on the court. So it says the following. Rule 49 subsection D. D. Filing. Documents required to be served must be filed with the court in the manner provided for civil actions in the Idaho Rules of Civil Procedure. So here you see you have a rule of criminal procedure which is adopting certain mechanisms or certain rules in the Idaho Rules of Civil Procedure. So again, let's just read it and then see if this is a little bit of a stretch. Documents required to be served must be filed with the court in the manner, and this is what the judge hung his hat on, in the manner provided for civil actions in the Idaho Rules of Civil Procedure. Well, what does manner encompass? So this judge was making the case, I think his name is Judge Bryce, I think his name is. So he was making the case that when it says in this rule that the documents have to be filed in the manner provided for in the Rules of Civil Procedure, that encompasses Rule 11. Because Rule 11 is a violation in the way, in the manner, in how you file your papers. And therefore he felt that Rule 49 in the Idaho Rules of Criminal Procedure really adopts Rule 11 in the Rules of Civil Procedure, and therefore that gives him the right to sanction Terry Ratliff. And he is sanctioning him. And he said that the sanction is, and in fact, it does say in Rule 11 that certain sanctions must be imposed by the court. It says the following: if after notice, this is from Rule 11, if after notice and a reasonable opportunity to respond, which is what this judge did. He gave him notice. We're having a hearing. He gave him the opportunity to respond to some of his questions. So if after notice and a reasonable opportunity to respond, the court determines that Rule 11b has been violated, the court must impose an appropriate sanction on any attorney, law firm, or party that violated the rule or is responsible for the violation. So he's saying, I don't even have a choice. I have to do this. That's what Rule 11 says. I must sanction you. And therefore, what was the sanction that he imposed? He imposed that Terry Ratliff has to now pay the attorney fees from the state that they had to spend time responding to this motion. And again, we don't see any of the filings here to respond to the motion, as well as the defense attorney, John Pryor, his time that he put in. So they're supposed to now submit their time that they spent on this motion and a reasonable hourly rate. And also, he's going to impose some sanctions on what the court's time and how the court had to spend time on this and his staff. So all those things are going to be together, and that is the sanction that Terry Ratliff is going to have to pay as a result of him filing this motion as an individual citizen. And that's one of the things that he claimed also, that really he had an attorney there. This is another part. He had an attorney representing him. And that attorney wanted to argue in this show cause hearing. And the judge did not allow the attorney to argue for him because he said Rule 11 sanctions does not allow an attorney to represent another attorney to defend against an imposition of a sanction. Right? You're not allowed another attorney to represent you. If you're in the middle of a case and you file something frivolous, the judge can right off on the bat order a Rule 11 sanctions. And you don't get to say, wait, hold on a second, judge, due process, I get an attorney. No, that's not the way it works. Not when it comes to Rule 11 sanctions. Now, the judge acknowledged that if he'd be facing jail time or anything like that, then of course he would be entitled to counsel. But here it's just in a Rule 11 sanction, which is a rule of civil procedure, and therefore you're not even allowed an attorney. So he had an attorney with him, this Terry Ratliff attorney. He had another attorney with him, but he didn't allow that attorney to argue for him. And then he said also that Terry Ratliff, since you filed this as an attorney, you're filing it as an attorney. And then he said, Terry Ratliff responded, well, I should have filed it as a citizen, just a regular old citizen. And he said, and then the judge said back, well, you didn't. You filed it as an attorney. It has your bar number. It has your firm. This isn't just you from your house as a concerned citizen trying to file this motion. This is you as an attorney. And then the attorney responded, well, this is just a question of semantics. And the judge says, no, this isn't semantics at all. It makes all the difference in the world. Because if you're filing something as an attorney, then Rule 11 applies to you. And that's what you did in this case. You didn't file this as a concerned citizen, that for some reason you have a right to intervene in this case and tell everyone that the case has to stop and continue. Now, I do want to mention also that there are certain times where we do find that the media intervenes for a limited purpose to just discuss the First Amendment rights and be able to get the media coverage of a certain trial in there. And that, I think, is where sometimes you find some case law that says, yeah, for First Amendment rights and the media covering the case and all the interest that's involved in that the media would have a right to intervene for a very limited purpose, not to continue a case. To continue a case is like, nobody wants to continue a case. And especially here, both parties, the main parties in this case, the state and Chad Daybell, don't want to continue the case. So you do occasionally find some sort of intervention when it comes to criminal cases, but the general rule is that there's no intervention allowed, and therefore that's what the judge found in this case. He sanctioned Terry Ratliff, and that was the fireworks that happened that have nothing to do with the actual Chad Daybell trial. All right, well, that's it for now. Thanks for watching. Please, if you haven't yet, subscribe, like, and we will see you next time.